Japan's privacy laws are primarily governed by the Act on the Protection of Personal Information, APPI, which regulates the collection, use, and management of personal information by businesses and government entities. The APPI defines personal information as information about a living individual that can identify the specific individual by name, date of birth, or other descriptions contained within the information. Additionally, personal information includes data that can easily reference other information to identify a specific individual, as well as any personal identifier code, like passport numbers or driver's license numbers. Sensitive information, which includes data on a person's race, creed, social status, medical history, criminal record, and other information that might lead to discrimination against the person, requires consent from the data subject for collection. The opt-out option is not available for third-party transfers of sensitive information. Prior consent from the data subject is essentially required. For online privacy, Japan does not have a specific law addressing cookies, but it's generally considered that cookies fall under the definition of personally referable information. The transfer of such data is regulated by the APPI in certain circumstances. For instance, if information obtained through cookies may identify an individual in conjunction with other easily referenced information, e.g., member registration, and it is utilized for purposes such as marketing, such usage of information obtained through cookies must be disclosed under the APPI. Regarding enforcement and penalties, if a business operator violates any provisions of the APPI, the Personal Information Protection Commission, PPC, can request a report from the operator, conduct on-site inspections, and request or order remedial actions. Failure to comply with PPC orders can lead to imprisonment for up to 1 year or a fine of up to 1 million Japanese yen for individuals. For entities, the penalties include fines of up to 100 million Japanese yen. Unauthorized disclosure of personal information for the benefit of the disclosing party or a third party is subject to imprisonment for up to 1 year or a fine of up to 500,000 Japanese yen for individuals. If an entity is responsible for the disclosure, it could face fines of up to 100 million Japanese yen. Japan also has specific regulations regarding email marketing under the Act on Specified Commercial Transactions, ASCT, and the Act on the Regulation of Transmission of Specified Electronic Mail, Anti-Spam Act. The ASCT requires sellers to obtain prior request or consent before sending email or fax advertisements to consumers and mandates record retention of consumers' consent. Violations can result in fines of up to 1 million Japanese yen. A notable case related to Japan's privacy laws is the Z Holdings Corp., formerly Yahoo Japan Corp., incident in 2013, where a system glitch led to the accidental disclosure of 22 million user IDs. Although there was no evidence of data misuse, the incident highlighted the importance of robust data protection measures and compliance with Japan's privacy laws.